Okay, good morning. Welcome to a session of oral arguments at the Fifth District Court of Appeal. This morning, we're first going to hear the case of Gursky versus Armour 21-1488. I'm Judge Evander. I'll be presiding this morning. I'm joined on the panel by my colleagues, Judge Eric Eisnagel and Judge Mary Alice Nardella. These oral arguments are being both streamed online, and they're also being recorded. And if you have any electronic devices or any cell phones, please make sure they're in the off position so the oral arguments are not interrupted. Ms. Harris, how much time do you wish to reserve for rebuttal?
Five minutes would be wonderful. Thank you.
All right, there is a clock on the screen, but I'll try to help you as well. And with that, you may proceed with your argument.
Good morning. My name is Elizabeth Harris, and I represent Shannon Gursky. I'd like to begin with what appears to be an agreement in our supplemental briefing that the property here that was held in the name of the trust is owned by a natural person. It appears that Mr. Cromash, as well as the amicus brief, agree that this property was held by a natural person. And coming from that premise, the argument then asserted by the appellee is that, but it was owned by a natural person, but the exemption does not pass to the heirs because the property was not specifically divided.
Can I ask you a question about that?
Sure.
I'm making the assumption, and correct me if I'm wrong, that it is your premise that it's held by a natural person because the homestead at the moment of death passes outside of the trust and directly to a qualified beneficiary. Is that correct?
Yes, but also married with it with the premise that the Florida Supreme Court asserted in McKean versus Warburton. The case law indicates to me that the homestead, I think they use the word in a twinkle of the eye, that it's an instantaneous pass from the decedent to the heirs.
What passes in a twinkle of an eye in the trust context? The probate context is a little different in that we don't have title already sitting in the estate. We have title sitting in with a natural person. In the trust context, we have a legal title that's sitting in the trust estate at the moment of the settler's death. So in your legal theory, what's passing in the twinkle of an eye? The title, the equitable interest, how does it work and when does it happen?
If I'm understanding your question correctly, at the time of if I'm understanding your question correctly, what I would assert happens is the benefit, because what we're dealing with is a will substitute in a trust. And it's the benefit that equally belongs, and the case law supports this. And when it's talking about the public policy behind homestead, that benefit belongs equally to the heirs as it does to the property owner, to the decedent. So would
it be your position that the transfer of the title is a ministerial act like it is in probate, that the beneficial interest passes at the moment of death, the transfer of the title is a ministerial act by the trustee?
And I think the case law would support that, because over and over we see cases that say the title, the manner in which the property is held, is not determinative of the issue. And those cases are cited in my brief and also cited in the supplemental brief, that the title is not determined. It doesn't end the question.
Would you agree that if that did not happen, and if it did not pass in the moment, in a twinkle of an eye at the moment of death, and instead remained part of the rest of a trust that became irrevocable, at that moment, you could not say that it was held by a natural person if the homestead is sitting in, is part of the principle of an irrevocable trust? Would you agree with that?
Well, I don't know that I don't know that I can assert an agreement with that, because I think that would be contrary to what the case law is telling us with respect to how title, that in and of itself doesn't transform the if we look at homestead sort of as a I'm trying to think of an analogy, but if it's more of a complexion of the property, that doesn't change if it's in the manner in which it's held. So I'd have difficulty answering your question because I think it would require a step away from the case law that talks about the title and the type
Counsel, what is there a case where the property is held by an irrevocable trust and the court concluded that the property was protected by homestead?
Is there a case that then
Right.
would be directly on point with ours?
You're saying it's not, that concept isn't supported by the case law. So I just wonder if is there a case that actually applies homestead where it's held in an irrevocable trust?
I think in I think it's pronounced Engelke. If it's not, I apologize, but I think that case talks about it's a revocable trust, and the property is determined to be held by a natural person.
The
And I
IRS
think
certainly treats,
I'm sorry, I spoke over you. Apologize.
the IRS certainly treats a revocable trust very different than it does revocable trust. They're not passed through. They're treated as a separate identity with their own number. They're given a different tax status and tax implications that come from that regarding what rates get applied to the earnings of that. So under what would the theory be that an irrevocable trust is a natural person? And would that theory also apply to corporations, which we have case law clearly saying are not natural people?
So I think where you're coming from with your question is the idea that the sheer idea of the death, which would change the trust from revocable to irrevocable. It's the idea of the death, and because the case law is telling us that title doesn't matter. I think it won't matter because the underlying factor that's changing is the fact that the property owner has died. And homestead certainly is separate and apart than what our tax implications would be. So I think the public policy that says if we have any doubt, we need to protect the homestead and the benefit to the heirs of the homestead.
But why, once the property is owned in this theoretical world we're talking about here, once the property is owned by an irrevocable trust, what makes it different than being owned by a corporation? For instance, maybe a closely held corporation where all the shares are owned by one person.
Well, I think the idea that this is something separate and apart than comparing it to a corporation, because that's not what we have here. So again,
Counsel, we're asking sort of potentially hypothetical questions, because this panel needs to understand all of the law if we're going to write an opinion on this issue, right? So how would an irrevocable trust be any different than, say, a closely held corporation?
The difficulty I'm having in responding is the idea of what did she intend when she put it in the revocable trust.
Well, let me ask you this. If she put it in a closely held corporation with the intent that it remain homestead, would that be fine then? If it's about her intent, then that would be okay.
Well, we know that intent is paramount with respect to homestead.
So
we
is
know
it- is it-
that's
I mean-
what the case law tells us.
Is it your position then that a closely held corporation would still be a natural person if that was the decedent's intent?
Well, I think we've provided case law, all of us did, perhaps the amicus didn't, that it finds that courts have found that separate and different than a situation that we have here, where there is a revocable trust, the individual dies,
Right.
and that property with the intent that it be preserved as homestead would
Right.
then pass
But
separate.
perhaps that's because the property is never held by the irrevocable trust. Assuming that this panel agrees with that concept, perhaps that's because the property is never held by the irrevocable trust. In the hypothetical situation where you have property held by an irrevocable trust, You previously said you could not agree that the property loses its homestead nature. And so I was just asking, why is it any different than a closely held corporation? Maybe your answer is that even a closely held corporation, the property would maintain its homestead status. Is that your position, that it's all about the intent and it's fine if it goes into a corporation?
Well, I haven't really formulated because I'm not dealing with a corporation. That's not what the situation at hand. So I haven't formulated. I wouldn't be prepared to formulate a response to whether that happened to a corporation here, because that's a separate set of facts than what we have.
What's the difference between a corporation, though, and an irrevocable trust? You have taken the position that homestead, the property could maintain its homestead status if it were held in an irrevocable trust. And I guess I'm struggling to see, for our purposes here, what the difference between holding it in an irrevocable trust would be versus a corporation.
Well, except for a trust function as will substitutes. I mean, that's I think the difference. They function as will substitutes. So when the will becomes irrevocable upon the individual's death.
No. Let's say
we're talking
the decedent put it into an irrevocable trust on day one.
Again, I'm not prepared to answer that because those are not our facts, but I suppose that.
Well, but doesn't this panel kind of
the intent would then be different because she couldn't pull that at any time. And that's what's important here. She could pull that at any time and say, I want to do something different with this property.
Right.
But
Counsel,
if
I
she's
see
done
that.
that with an irrevocable trust.
Yeah, we have what's divided, and we understand that she had the power to revoke, and therefore you can argue that it's not vested. But I want to talk to you quickly about, I know you're running out of time, the title in this case.
Mhm.
If this homestead passed outside of the trust at the moment of her death, what power did the trustee have to sell the homestead after our settler passed?
So I think you're asking whether there's a specific direction in the trust to sell the property.
No. I'm saying if your theory is right, and I understand your theory to be, this is just like probate because it's a will substitute, and because it's just like probate, our homestead passed twinkle of an eye at the moment that our settler died. If that's true, then the homestead is no longer part of the principle of the trust, just like it would never become part of the probate estate, correct?
Right.
If it's no longer part of the principle of the trust, then how does my trustee have any authority, unless it's given to him from the qualified beneficiaries, to sell this homestead?
I don't think he has any authority to sell the property.
Ms. Harris, I think the way the questions were going on the irrevocable trust is, if you are correct that upon the decedent's death, the property, with the twinkling of an eye, went to the beneficiaries as homestead, that's one result. If it goes to an irrevocable trust, that's potentially a different result.
Sorry, I thought I had them all turned off except for the office line itself. I so apologize. I took care of my cell phone, not the office
No,
line.
Counsel,
So
that's not a problem. I think it's probably happened to all of us.
So what is an irrevocable trust? Would it be viewed as a will substitute, such like a revocable trust is often viewed as a will substitute?
So in my panic over the phone, I think you were asking me if the revocable and the irrevocable trust both function as will substitutes.
Right.
And-
We understand your case law that the revocable trust can be characterized as a will substitute. There is case law to support that. So question just is irrevocable trust. Is there any case law that suggests that follows as a will substitute? Or should that be treated differently? For instance, if in this case, we're looking at a broad picture here as far as an opinion. If the property here had originally been held in an irrevocable trust, would the result be different?
If it is an irrevocable trust, I think I'm not confident that and I haven't fully thought this through, but I'm not confident that the retention of the homestead would look the same. And certainly then we become a question of whether you're gifting the benefit or whether you're gifting the proceeds, the monies. You know, there's case law that talks about gifting the money as opposed to gifting the benefit. And I think here, you know, we've got a clear direction that she's gifting that she's retained the benefits. So it's not a question of I'm gifting the money, you know, in comparison to the other cases. So I think that the idea of it changing, I'm not. I don't believe that the focus changes with the revocability, the lack that it can't be revoked
Right.
after she's died. I don't think that then has a retroactive effect of coming to what's happened there. She clearly retained her, and she clearly didn't specifically devise this. And I would assert that that's where we're in disagreement, is the Warburton case says precisely the opposite of what the trial judge did here. So that, I think, is the answer. I think that might be the answer to your question, or my answer to your question.
Counsel, in your rebuttal,
Let me just, you're at 4:40, but I'll let Judge Eisenhower proceed with this question. But just to
this
make-
might be a case where we give both parties more time. We'll see. But in your rebuttal, in Gelke case, I pronounce it in Gelke. Maybe that's wrong. Is that the case you were referring to earlier in response to my ENGELK? I'm pretty sure that was a revocable trust, not an irrevocable trust. Maybe I might be misremembering because I've read so many cases, so many opinions. But if you could look, I guess my question is on the irrevocable trust, and I think Judge Evander was asking essentially the same question I was asking. Is there? I understand your position that perhaps that doesn't change the analysis, but I guess our question is there any Florida opinion that's actually addressed it in the context of an irrevocable trust? If there is, we would obviously want to know that. So maybe in your rebuttal, you could think about it. And if you can think of one, tell us in your rebuttal.
Sure, I'll do that at that time.
Thank you.
I have another rebuttal request.
Okay, I
Mine
maybe
is-
need to write these
apologize.
down.
It deals with Almowitz. In your brief, you say Almowitz is factually distinguishable. I want to know from you if you think Almowitz was wrongly decided and wrongly reasoned.
All right, thank you. All right, Mr. Cromash.
Thank you. Good morning. May it please the court. I'm Keith Cromash on behalf of the appellant of the appellee, Harry M. Armour, in his capacity as personal representative of the estate of Nancy K. Armour. I'd like to address the court's questions that you're dealing with the appellant first. And the first one I want to talk about is the twinkle of the eye question, and whether in this situation or where you have a revocable trust, whether the trust property does vest in a twinkle of an eye. And I would submit that it doesn't. And the reason it
I'm
doesn't,
sorry, you're suggesting it does not?
it does not.
In this
And the
case, or generally speaking?
In this case, and I would say in all cases involving revocable trusts.
Well, I thought in your brief that you kind of agreed that it did maintain its homestead status, but the protections against claims of creditors did not inure for two reasons. One, that it was not a specific device, and two, that it was a special direction of sale. So are you taking a different position than your brief, or am I just misunderstanding
No,
the argument here?
this is the position that we take. You have to look at the Constitution. Under Section 4A of the Constitution, that's the protection from forced sale. And that's where we start with the natural born person. With the case law holds that in revocable trusts, under Section 4A, and indeed under 4C and 4B, a trust is deemed to be, a property owned by trust is deemed to be owned by a natural person. Then what happens when the grantor of the trust dies? The natural person is no longer a question. The question is, was it owned by a natural person? The question on passing to the heirs is, does that exemption inure? And whether the beneficiaries are natural persons isn't the question. The question is whether the grantor of the trust was a natural person. And I think all the parties agree in this case that, and the case law says, because the wills are these trusts are will substitutes, and in cases where grantors have the right to reside in the property, the policy supports finding that the property was owned by a natural person. But
All right, so if the trust in this case said that had a specific statement that the property goes to the heirs and that it will not be used to pay any creditors, would you agree that's homestead, even though it went from a revocable trust, into this trust?
yeah, absolutely. If this had been a trust that didn't have Article 5, which was the specific direction to pay debts, and if there had been a specific bequest of the homestead to the heirs, then I would absolutely agree that the homestead would inure in the heirs. But
All right,
that's
let me
not,
ask about the specific bequest. There's two Florida Supreme Court cases, at least, that reference that homestead can pass through a residuary clause.
right.
So why, and here, the residuary benefits are the two heirs. So help me with that argument.
Yeah, so I think the argument is, well, first of all, Elmowitz is the case that we relied on and the trial court relied on. And I think I heard Judge Nardella ask the appellant whether Elmowitz was wrongly decided, and maybe that's the case. There is some academic commentary on Elmowitz saying that's an outlier, maybe a wrongly decided case. But it's out there, and it clearly says that where there's a residuary devise, the property becomes part of the principal of the trust and becomes just another asset of the trust. And in that footnote 1 of the Elmowitz case, the court clearly says the property loses the homestead exemption. And it's clear that the court is stating that the exemption doesn't inure under Article 10, Section 4B.
Let me ask you this. Elmowitz was a third DCA case. And subsequent to that was a Cutter case, which went in bank. And interestingly, I don't believe they mentioned Elmowitz anywhere, but there they did find in a similar situation that it did go and did keep its homestead status at the time of the decedent's death, but they found in essence, I think it was 8-3, that was a specific devise, a specific direction to sell the property. 3 of them said no, it wasn't a specific direction, as general, and therefore the homestead status remained the same. So it seems if, for the proposition that the trial judge used Elmowitz, that arguably all 11 judges on the in-bank went the other way from the same court, even though I agree, they never mentioned Elmowitz.
Well, I think you can still affirm the lower court, even if you disagree with Elmowitz. And the reason is because I think the Article 5 issue, the payment of debts clause, is way more important than the Elmowitz issue.
You know what's
And
interesting,
is that,
Mr. Kubash?
is that the primary issue here?
I
So
believe
that's
it
a
is.
general
I think
specific.
that's everything, because again, getting back to
Mr.
Judge
Kubash,
Nardella's.
so what's so interesting about Article 5 is, doesn't it start with whatever is remaining in trust? Whatever is remaining in trust. If this property, if this homestead is not remaining in trust, then Article 5 doesn't matter.
Well, that's exactly right. And that's what I was trying to get to with the nature of trusts. When you have a trust, this is a general principle of law. When you transfer real estate to a trust, there's a bifurcation in title. There's legal title, which is held by the trustee, and then there's equitable title, which is held by the beneficiaries. And that continues even after the decedent died. And in fact, the trial court made a specific finding of fact on this. The trial court made a finding of fact that the decedent intended that the trustee would hold title during life, and that the successor trustee would hold legal title following death. So to your point, Judge, when Article 5 says that the trust shall use income or principal or both to satisfy debts, and keep in mind, unlike in the Engelke case, there's no precondition here. Engelke, the payment of debts clause said only if the estate is insufficient. In our case, there's no precondition. It says the trustee shall use trust, principal, or income, or both to pay debts. So getting to
I
your
want to
point, Judge,
commend you for citing the new Florida statute 736-1109 in your answer brief. And I want to ask you a question about subsection 3, and I'm going to just paraphrase the statute, shorten it up for our purposes. It says, if a trust directs the sale of property, title shall remain vested in the trustee and subject to the provisions of the trust. It seems to imply, at least to me, that if it doesn't direct the sale, then title doesn't remain vested in the trustee and subject to the provisions of the trust, which seems to comport with the twinkle of an eye theory that I need you to help me with that.
Yeah, so Aronson is the case that talks about a twinkle of an eye. And you have to keep in mind what Aronson was. Aronson was an invalid devise case. What happened in Aronson was that it was in a revocable trust, and the decedent made an invalid devise. So under the statute, I'm drawing a blank on the section. It's like section 732-401. The result when there's an invalid devise is that it's a life estate to the spouse with the remainder to the decedent's children. And that's what happened. That's the twinkle of the eye in Aronson. What happened was, because there was an invalid devise, the property passed in accordance with Florida statutes. That's the twinkle of an eye. But the result would be different if there's a valid devise. If there's a valid devise, what happens is the trustee retains legal title. So I don't think Aronson helps. My background just fell. I apologize.
Oh.
I was trying to.
How did our trustee sell this property? How did the trustee sell?
Well, and that's exactly it. The reason the trustee was able to sell the property, and the title company recognized this, and the court recognized this in the lower court's order. The title company recognized that the trustee had clear legal title and was able to sell the property. In fact,
I'm less concerned with what the title company recognized and more concerned with why.
Why should this panel be controlled by what the title company said?
well, you shouldn't be controlled by the title company. Obviously.
What relevance does it have?
Well, what relevance it has is it shows that a title company, which has a financial interest in underwriting a proper transfer of title, found that the trustee was permissible or was capable or had legal title and was able to sell the property. I think this is completely consistent with the principle that a trustee holds legal title. Again,
Counsel, I still don't understand why your argument as to why the homestead does not pass in the twinkling of an eye out of the revocable trust at death. Could you go into an in-depth explanation as to why
sure.
that concept happens in one circumstance but not here?
Yeah. So in the estate, I absolutely contend that there's a difference if you have the same provisions in a will and you have the same provisions in a trust. Because in an estate, the homestead, as long as it's a valid devise, which in our case, there was a valid devise. This isn't a case where there's a spouse or a minor child, where under 4C, there's a restriction on devise. The decedent was free to devise it through the residuary clause to her adult children. So there's a valid devise. And so in an estate context where there's a valid devise, there is the homestead property never becomes part of the estate. That's why it vests in a twinkle of an eye. In the trust context, the trustee, unlike in the estate context, actually owns legal title to the property. And that's the difference. The nature of trust makes all the difference in this case. It makes all the difference in the world. The trust.
Explain it to me.
Well, the bifurcation of title. When an individual owns title to a homestead property or any property, they own both legal and equitable title. There's no bifurcation. When a trustee owns property, the trustee only owns legal title. The beneficiaries have that equitable title. That's that bifurcation. And so during the period of the time that this trust is in existence, both before death and after death, the trustee maintains legal title to the property. And that's why the trustee was able to sell the property. And that's why there's not an immediate
But not
vesting.
equitable title,
Not
correct?
equitable title. No, the beneficiary always has the equitable title.
Right.
And while the decedent was alive, the decedent at that time had both legal and equitable.
I mean,
title.
why isn't the equitable interest controlling? I mean, it seems like it might be, right? I mean, there's plenty of cases out there saying that, hey, it's still held by a natural person, even though it's in a trust, because it's revocable. Equitable
Well,
interests being as they are, right?
I think if you want to say that that the homestead vests in a twinkle of an eye in the trust case, then I think you have to ignore all this law that exists that bifurcates legal title from equitable title. I don't see.
Why do we have to ignore it?
Because the trustee is still, there's a successor trustee, and the successor trustee is still holding that legal title. This begs the question, and this is something, it's interesting that the real property.
What
and probate
happens when
trust
a
law-
party, what happens when a party is holding legal title, but they don't have the equitable interest?
in what
Are they
context?
entitled to, I mean, are they entitled to just do with the property as they will? Where's,
No,
where,
no, the trustee has a fiduciary duty to the
which interest,
beneficiaries.
well, yeah, which interest is superior?
I think the beneficial interest is, if you have to compare the two, the beneficial interest is probably superior.
It seems like it is. So why wouldn't the beneficial interest be controlling?
Because the beneficiaries don't have any legal rights to deal with the property while it's still titled in the trust. The beneficiaries couldn't sell the property. The beneficiaries couldn't mortgage the property.
Could they force the
beneficiaries
trustee
couldn't
to,
gift the property.
could they force the trustee to deed the property over?
Depending on the terms of the trust, they could. But the
But if
question is,
equitable interest passes, if the equitable interest is not in the rest of the trust, then can creditors attach to the proceeds of the sale of homestead? You're saying yes. Why is that?
well, I'm saying yes in this case because of Cutler, because of the Article 5, because the specific direction to use trust assets to pay for administrative expenses.
But Cutler was a
If this
little
court-
different, right? I mean, it's a land trust. The provision specifically says out of my homestead and this adjacent property, I want you to first satisfy. Why is Cutler not distinguishable on that?
Well, Cutler, I'm not saying that Cutler is right on point. It's not right on point, but it stands for the proposition that when you have a specific direction to use property, and in this case, use property that's part of the trust to satisfy debts, that's the functional equivalent of saying, sell the property and then use the proceeds to satisfy those debts. That's why Cutler's
Counsel,
supports.
Let's go with your position here for a minute that that the property stays in the trust even once the trust upon death the trust becomes irrevocable. The property stays. It doesn't pass in the twinkling of an eye. What happens first? My first question is what happens to the beneficial or equitable interest upon death? Titles remains in the trust, but where does that equitable or beneficial interest go?
Well, the beneficial interest is held by the beneficiaries.
Okay,
And that,
so
that-
does it pass? Does the beneficial interest pass in the twinkling of an eye to the heirs, or does it go into the trust? What happens, or does it just sort of sit in the air for a while?
well, I would submit that the beneficial interest exists upon the creation of the trust. I mean, the beneficiaries in this case, they're remainder
Upon death.
beneficiaries. Well,
Upon
they're
death.
actually-
Where does
You're-
the beneficial interest go? What
well, upon
happens?
death, the beneficial interest remains with the beneficiaries. But my argument, my
Which is
point
who?
here,
And hold on, in this case, which is who?
the appellant and the appellee.
Okay. What-
The children of the
okay.
decedent.
So you agree that the beneficial interest passes in the twinkling of an eye?
Well, I wouldn't say it passes them twinkle of an eye. And the reason I say that is because when the grantor created the trust and she named her children as beneficiaries, they already had that equitable interest as remainder beneficiaries. So
But it wasn't vested yet, right?
it wasn't a vested interest, but they're considered under the trust code qualified beneficiaries, even though their interest hasn't completely vested.
I'm not
So
sure they
still
had the
have that
beneficial.
equitable interest.
Counsel, can you cite me some law for the proposition that they had the equitable or beneficial interest in the property before death?
Well, what I would say is that they are qualified beneficiaries, and as
Okay,
qualified beneficiaries, they have certain rights.
But
Now,
that's not
granted, they
really.
don't have
I-
as a revocable trust, they don't have a right to,
It doesn't
certain-
seem like that's what I was asking. Though I was asking the equitable interest or the beneficial to the property before
Right,
death.
well-
Okay, let's not confuse the two. It seems like those are two different things. Do you agree?
Well, I would agree that upon death, the beneficial, the immediately upon death, the beneficiaries held beneficial interest or equitable
Okay,
interest. I
all
would
right,
disagree
so-
with that.
Whether we call it blink of an eye or something else, the point is the beneficial interest immediately went from decedent to appellant and appellee.
But the legal interest didn't, and that's.
But the
that I think is
but
the
your
key.
point is the legal interest stayed in the trust, which
That's
is now
exactly my point.
which is now irrevocable.
Correct, Your Honor.
Take us from there. So your point is we shouldn't be distracted by the beneficial interest. We should focus on the title itself, who holds the title, and that
Right,
remains in the
legally.
trust.
And again, I think you have to look at the intent of the decedent. And the intent of the decedent, one of the intents of the decedent was that all of the provisions of the trust would apply to the assets of the trust. And if that's the case, then Article 5 has to apply to the trust, or has to apply to the property.
Well, forget
And-
Article 5 for a minute. What if our Article 5 didn't exist? I'm just trying to figure out the mechanics of what passes when.
Well, if Article 5 didn't exist, or if Article 5 were a general direction to pay debts, and when we put Elmowitz aside for a moment, then I would say that the homestead would pass and the exemption would inure in the beneficiaries. It's Article 5 that's
But
the
no,
issue
no,
here.
hold on. Now, title would still be held in the irrevocable trust upon.
No,
death.
but what I'm saying, Your Honor, is that Article 5, what happens is the title vests. But
Mhm.
when you look at the language in Cutler, it vests, but it's subject to the claims of creditors. That's how the court words the language in the Cutler case. And so in this
Well, I mean,
case,
the trust specifically said to do so, though, in Cutler. I mean, very expressly said, use my homestead to pay debts.
Mhm.
Right?
well, I think if you take maybe another way to look at this is to compare this case to the Engelke case. I think I mentioned this a little bit earlier. When you look at the payments of debts clause in Engelke, it was a condition. It said only if my estate is insufficient do you use the trust funds to satisfy my debts. Compare that to Article 5. It's a blanket mandatory, use the trust funds to pay my debts. So then I think the question then becomes is, given the fact that legal title is in the trust, does that direction direct the trustee to use the trust property to satisfy debts? And I submit that it is. And that's why I submit that the lower court got it right in denying the amended petition to determine homestead status of real property.
Mr. Cromash, let
Again-
me ask you this, and I'm going to let you go, probably give each of you another 2 minutes, but, I think at least where I stand right now, what you said earlier is that whether this is a special direction of sale or general is, the primary question, maybe the controlling question. So first of all, if it's a specific or special direction of sale, you win. Would you agree with that?
Yes.
And that's the third question for you, Ms. Harris, when you get up for rebuttal. If we disagree with you and hold that the trial judge erred, one of the things the trial judge did was said both the estate expenses and the trust expenses are something that the property that was homestead for the decedent when she was alive could be used to pay those debts. If we disagree with you on the main point, though, can the homestead be used to pay any of those expenses?
Yeah, I think if I'm being completely honest, and I hate to have to say this because it hurts my client's position, but I agree that if you find that this was a general direction to pay debts, then the trial court was probably wrong. I think this case hinges on a finding that was a specific direction to pay debts. Because if it's a general direction, you look at 736-1109, that statute is retroactive. It looks pretty clear it was retroactive, and that statute, which is just a general statement of the law anyway. It's not, I don't think it's anything new. I think it just states what the common law is. But the common law says clearly that a general direction to pay debts has never trumped the constitutional protection. And that's what the Engelke case says. But this is, again, I think this case is different. I mean, you have to really
without Article 5, you agree. You agree that without Article 5, the legal title would not be enough.
I agree that if Article 5 were a general direction to pay debts, then the homestead would pass and the exemption would inure to the heirs, and we would lose.
And the
I agree with
beneficial, so that's what I was trying to get at before. The beneficial interest would prevail in that circumstance, but you say, hold on, there's a specific directive here from the decedent in Article 5. That's your point.
That's exactly right.
Okay. All right.
All right, Mr. Cromash, I also want to echo what Judge Nardella said and commend you for raising the statute in your answer brief. So
Thank you, Your Honor.
thank you. And Ms. Harris, rebuttal.
Judge Eisnagel, I'll start with your question, and I pronounce it Engelke too. And you're correct, Engelke is a revocable trust. But I think how, and with relation to, and I'm not aware of a case where the from the onset, the property was placed in an irrevocable trust. But I think what we're dealing with here is sort of these concepts that make homestead so unique. If it passes in a twinkle of the eye, the change from revocable to irrevocable, I would not agree that it acts as a trap door. That now it's trapped in this irrevocable because it's.
Well, if it passes in the twinkle of an eye, it sort of avoids the problem unless it was put in an irrevocable trust to begin with, right?
I think that's particularly because title isn't the determinative issue. So because we've got this benefit that is equally the to benefit the heirs. So we've got these two kind of concepts that are passing simultaneously, and to come from the premise that, you know, we've got a trap door that now traps this benefit in their irrevocable trust would defeat the idea of legal title and benefit belonging to the heir, because they're kind of going on at the same time. So once this lady dies, her benefit, it conceptually goes this way rather into the irrevocable trap door. If we're looking at two pathways, it doesn't go this way, it goes this way in that very moment of death. So I think that's the answer to your question. I did a quick review of the cases that I looked at. I don't think any of them put that property in an irrevocable trust to begin with. But Engelke is a revocable trust. You know, the individual dies, and they find it to be a natural person owning it. With respect to the Elmowitz case, you know, I feel like I now have this case almost memorized. I could recite it to you. I've looked at it so many times. And I'm not confident, quite honestly, if there's simply facts missing in this recitation of the facts, or if it is just wrongly decided. Because the reason I hesitate in boldly saying it's wrongly decided, one is to give deference to the court. And secondly, it
I
says,
apologize, wrongly decided was the wrong term. I should have said wrongly reasoned.
or maybe outlier, or some other. I hesitate in answering this question boldly and say but it's clear I disagree with the outcome. The reason I am not confident is because it says Zimmerman's will devised her homestead to Zimmerman's trust. So are we talking about a specific devise of the property? That's a fact that's missing for me here, whether that's what happened. And then I would say, then this case might go along the Warburton path.
In your theory, does specific versus general devise matter?
I think it absolutely does, given what the Supreme Court ruled about 11 years after Zimmerman. It has to, because they talk about if there is no specific devise, it is a general, and it then passes in the absence of a specific devise. The property passes through the residuary. Judge Evander referenced it earlier, and that's sufficiently precise indicator of testimony intent to pass homestead protection. So I think it definitely does. Where Elmowitz causes further confusion, and again, it could very well be that there's things that we don't know from the opinion. But when you look at footnote 1, it then says the property was not specifically devised to the sister. So I don't know how we reason these two sets of facts, but if we look solely at footnote 1, this opinion is in conflict. Maybe that's the way with Warburton. It has to be in conflict because they talk about how if there is not a specific devise, it falls through residuary and there's enough there to protect the homestead. And Judge Evander, I apologize, I didn't write down your question, so I don't recall what
Well,
you
the
asked.
question is, if Article 5 is a specific or a direction to sell or to be used against creditors, do you lose the case?
If it's a specific direction, if it specifically directs it to sell that property, much like and I would suggest the language needs to be more like it is in Cutler, where it's a specific, I think then we've got a problem.
Okay,
If she had said, please sell my homestead, if there's not enough in my estate, please sell my homestead to meet the other devices. And
your
I'm
time
not
is up.
recalling which case dealt with the
I'm going to stop you here because your time is up. I do want to thank both attorneys for their arguments, both written and oral today. It's an interesting case, interesting arguments. The office phone and the collapse of the background screen just added to the entertainment value. So thank you both, and we'll be in recess.